Good morning, everyone. My name is Andrew Podgiersky. I'm a partner with the Houston office of Louis Brisbois and also chair of the Ukraine conflict response team. We have 18 members in our team, and in the last year and a half, the team generated over 75 legal alerts with respect to various legal issues related to Russia-Ukraine conflict. I would like to welcome all of you to this webinar, Under Pressure, Evolving Legal Landscape of the Russia-Ukraine Conflict.
In May of 2023, FinCEN and BIS issued a joint alert, very important, and you'll hear more about this, identifying red flags that companies should be aware of with respect to sanctions evasion. And an interesting twist now is in September of this year, the SEC has launched a prosecution of civil forfeiture case in the Southern District of New York against a company, Concord Management, that violated and failed to register under the Investment Advisors Act of 1940 when it was acting on behalf of sanctioned Russian oligarchs.
The Biden administration now has the authority to send the proceeds from the sale of certain Russian oligarchs' assets to Ukraine, thanks to Section 1708 of the Consolidated Appropriations Act of 2023. Pictured is a 340-foot yacht Amadea. It's worth over $300 million. In fact, its annual operating costs are between 25 and 30 million. The Department of Justice alleges that Suleiman Kerimov, who has been on the SDN list since 2018, owns the Amadea. Mr. Kerimov denies ownership and asserts that the yacht is owned by Eduard Hudanaitov. But Mr. Hudanaitov allegedly owns several half-billion-dollar yachts. And U.S. klepto capture director Adams said to own several half-billion-dollar yachts as a mid-tier industrialist is totally implausible.
Some general coverage considerations. So when you first look at whether or not a loss is covered, you turn mainly to the language of the policy, the applicable law, and the governing jurisdiction, and the facts surrounding the loss. In the United States, insurance policies are interpreted with contract law, and only if there's an ambiguity will courts consider evidence outside the four corners of the policy. And typically it excludes property losses or damages that result from acts of war. However, as the Smart case illustrates, you can't just turn to a war exclusion clause and automatically assume that every loss related to the Ukraine conflict is going to be excluded out of coverage. We're seeing a number of lawsuits now related to the aviation disputes. There's estimated to be around 400 leased aircraft stranded in Russia. And mainly the disputes are occurring in London, Dublin, and the United States. Here in the United States, one of the cases that we're following is this Air Castle case in New York. Also, we're following this London combined mega lawsuit, where earlier this year, the High Court in London decided to combine a number of cases and set trial for later next year in October.
And just last week, General License 8H relating to energy activities was updated to its 8th iteration and will expire in May of next year. Furthermore, other recent exceptions to Directive 2 are provided in General Licenses 50 and 52 that allow for closing accounts of non-block persons at a block bank, as well as operations for diplomatic services. And enforcement actions have continued this year. In April, OFAC and BIS fined Microsoft $3.3 million for software transfer violations. And in June, OFAC issued an order against Swedbank Latvia, penalizing it for facilitating the financing of a shipping company in Crimea because the nexus was that it used a correspondent bank in the U.S. in the process.
So I first want to talk about the state of Florida and the law that was put into force July 1st of this year, Senate Bill 264. It's called the Interests of Foreign Countries Act. Essentially, with respect to the Russian citizens, it imposes certain restrictions when it comes to buying any kind of real property in Florida. And that includes commercial, residential, and agricultural.
The big issue is which forum am I going to end up in? Because that's going to profoundly affect contractual defenses. And who needs to be worried about this? Well, both companies who can't perform because of the risk of sanction violations because the counterparty is affected, and the actual companies directly subject or impacted by sanctions. A governing law provision in a contract is going to be enforceable if it is thoroughly drafted to cover both substantive and procedural law applicable to the dispute. If you don't have a thorough drafting, the contract is going to be found to be governed by a state with a closer relationship to the issues.
We are hearing from clients, and the questions are getting increasingly knotty and complex. But they center on recently additional sector sanctions additions, such as for engineering services, and in many cases, how a particular sanction interacts with a different sanction.
I would like to thank our speakers for their presentations and responding to various questions and for their answers as well. Thank you again and have a wonderful day.